Any mention?
Please, Lordship. Lordship, I beg to mention item number 24. Lordship, I'm seeking adjournment for today. If matter would kindly come after 2 weeks now.
Yes.
No objection, my lords.
When do you want it?
After 2 weeks, Lord.
Yes. The request for petitioner, list after 2 weeks. Yes.
Highly apprised.
May it please your Lordship.
Yes.
Lordship, I beg to mention item number 19.
Yes.
Lordship, I pray that this matter may kindly be taken up after 3 weeks.
Lordship, I have no objections.
19. On request made by the learned counsel for the appellant, list is met after 3 weeks. Yes.
Team
Obliged, Lordship.
May it please your Lordships. Your Lordships, I beg to mention item number 18, Your Lordship.
Yes.
Your Lordship, the conducting counsel is indisposed. I pray that the matter may come up after 2 weeks, Your Lordship.
18 also. 2 weeks.
2 weeks, Your Lordship.
2 weeks. The request of the petitioner. Yes.
Right, Your Lordship.
Yes, Your Lordship. Your Lordship, I beg to make a mention of item number 12, Your Lordship. I pray for 3 weeks' time, Your Lordship.
No objection, Your Lordship.
And for the private respondents on 4 and 5.
No objection.
No objection.
So on prayer made on behalf of the petitioner, not objected to the learned counsel for the respondents, list after 2 weeks. Yes.
Lordship, I beg to mention item number 15 and 16. Lordship.
Number 16.
Lordship, here I am praying 2 weeks' time to file my affidavit in opposition.
In both the matters.
Lordship.
Lordship, affidavit in opposition has already been filed. It's on the stay application that they want to file it, please.
In both the matters, affidavit in opposition has been filed.
No, Lordship.
Yes, Lordship.
2 weeks' time, Lordship.
No, affidavit in opposition or?
For the stay application, my lord, here
That
to file the counter, my lord.
Oh, what about the main case?
Main case, it has already been
They've all
filed.
been filed, my lord.
In both the matters?
Yes, Lordship.
Lordship.
Yes, Lordship.
No, but then if affidavit in opposition filed the main case, is there any requirement of filing?
Even item 3 also, your lordship, is the same issue in the item number 3 in the to the list, your lordship. Same issue in the order column, item number 3.
These are all those Lokayukta matters.
Yeah,
Yes.
let this matter be listed together, you know.
That item number 3 also affidavit has been filed.
Yes, Lordship. I'm praying the time, Lordship. 2 weeks.
No, it's filed or you are asking
No,
for
no, Lordship. I'm praying 2 weeks' time to file, Lordship.
in all the matters? So,
The Lordship,
but
item
then
number 3.
the petitioner says that affidavit has already been filed.
No, Lordship, not in item number 3.
3 has not been filed. Okay, 3 will take up when it
Yes,
comes.
Lordship.
But then this 15 and 16.
Appearing for
15, 16,
No, but then if
Lordship,
it is-
if I
if it
may
is-
apprise this Honorable Court, if I may apprise this Honorable Court, Lordship, in the main writ petition, the affidavit in opposition has also been filed, and we have already filed our rejoinder also.
In both the matters.
Yes, Lordship, both the matters.
Yes.
Subsequently, we had filed a stay application, and the private respondent number 2, they had filed an application for impleadment of the secretary and the chairperson of Lokayukta.
I'm
So in
representing
that
victim.
particular application also, we have already filed our objection, the impleadment application. And so far as the stay application is concerned, they have not filed objection. So it seems that my friend is praying for time to file objection against the stay application.
Which one is the stay application? Which case is the stay
This
application?
case.
For both the matters, my lord, item 15 and 16.
So it means there are 2 miscases pending.
Lordship.
Miscase.
Yes, Lordship. One is for impleadment and one is the stay application.
New one.
Miscase number 1 is
One is for, I think, stay, my lord. Because in this case number 2 of 2024, I'm appearing. This is for impleadment of Lokayukta.
that is yet to be disposed of. This impleadment application is yet to be disposed of.
Yes, sir.
Yes, Lordship.
Who wants to file objection in that application?
We have already filed objection, Lordship.
In that, so it means time is only sought in this stay application.
Miss case.
Lordship.
And what
Yes,
about
Lord.
that miscase number 5?
We are here to file the objections, my lord.
I'm praying time, Lordship, to file my
No, what is that 5? What 5 is with regard to what?
My lord, this
seeking
is for the
stay.
stay applications, my lord. We had filed.
So if one is for stay application, how many stay applications are there?
Lordship, in item number, initially at the time of filing the writ petition, we had filed one stay application, and subsequently, due to certain developments, we had filed a separate stay application. So there are in total two stay applications.
No, initially the stay application was not pressed, but subsequently, my lords, once the trial court, my lords, was proceeding ahead with the matter, thereafter a separate application was preferred, my lords.
What about the initial stay application? Is it still surviving?
No, it is survived. No orders were passed, my lords, in that order, in that particular application, my lords.
In the first
Yes, my lords.
in the first application,
Yes, my lords.
it seems a bit confusing. We need to see the records before we pass any order.
Right, my lords.
Just wait. Let this matter be called.
Lordship.
15 and 16.
Please, Your Lordship.
Yes.
Lordship, I beg to mention item number 20, Your Lordship. With a week's accommodation, Your Lordship.
Item 20.
Item 20, Your Lordship.
You are for the appellant.
For the appellant, Your Lordship.
No objection, my
This was on the request made on behalf of the appellant. When? How much time?
2 weeks, Your Lordship.
This is matter after 2 weeks. Yes.
Much obliged, Lordship. Please, Lordship. Lordship, I beg to mention item 10. Lordship,
Yes.
Lordship, there's 3 analogous matter in this item, Your Lordship. And Lordship, in one of the matters, Your Lordship, the petitioners is since deceased, Your Lordship, we had filed substitution application, Your Lordship. But Lordship, a common order was passed, Your Lordship. So we're
Petitioner
supposed
is
to file.
supposed to pass substitution application.
Yes, Your Lordship.
Yes.
Lordship, we are supposed to file a recall, Your Lordship, because a common order for substitution has been passed in all 3 matters. So, Lordship, I'm seeking for accommodation, Your Lordship.
No, what for? What for seeking accommodation?
We are awaiting signature, Your Lordship,
For?
to file a recall, Your Lordship.
Okay, in these other 2 matters.
Yes, yes, Your Lordship.
And what about this substitution application?
We have to file an undertaking, Your Lordship. I'm seeking instruction, Your Lordship, because. Yes.
Oh,
Lordship, in one of the application, Your
just say. Any objection?
No, my
Just say,
AG is the main contesting count.
just say on prayer made on behalf of the petitioner, not objected to by the Illinois Council at the time of the respondents. When do you want it?
after 2 weeks, Your Lordship.
List after 2 weeks. Just all these 3 matters in item 10.
Highly obliged.
Please, Your Lordship. Lordship, I beg to make a mention of item number 17. Similar matter is pending before the division bench. 17.
POXO matter.
Yes, Your Lordship.
Okay. Yes. We'll have it after when?
3 weeks, Your Lordship.
3 weeks. 17, 3 weeks on the request of the petitioner. Yes.
My lord, I beg to mention item number 22 and 23, my lord. Here the appellant has already summed up his argument and written argument has been filed, my lord. I'm preparing my written argument, my lord, in this case. 22 and 23.
The appellant has closed his argument.
Written argument submitted, my lord. It's my turn to.
Okay, your time to reply. Okay, yes, sir. Any? How much time you want?
2 weeks, my lord.
Yes.
No objection.
You are for the appellant here.
Yes, Your Lordship.
Yes, sir. On prayer made on behalf of the respondent. Not objected to by the Illinois Council applying for the appellant. List after 2 weeks.
Deeply object.
This 22, 23, both the matters.
Yes. Both them.
May I please, Lordship?
Yes.
My Lord, item number 13 and 14, my Lord.
Yes.
My Lord requires some accommodation
Yes, when do you want it?
after 2 weeks.
Any
No
objection?
objection, Lordship.
No, the request to the petitioner, not object to by the respondent, list after 2 weeks. Yes.
Item number 1.
May I please, Lord?
Where it is in the admission column? It should be the orders. This one, where it is in admission? This admission. Which one?
Whether this is a supplementary list or daily list?
Daily list. Huh? This is.
You are mentioning supplementary list or?
There is no. Just a minute.
Oh, then this is item number 1 is mine.
Wait. There is a previous council.
So I showed you this.
No
This is
supplementary.
the item number 1 has come up for admission, isn't it? So whether it has been admitted or not.
It was admitted, Your Lordship.
It's for paper book.
Yes, paper.
It's for paper book, my lord.
Criminal case. It means the same thing. Criminal appeal. Everything is there. This is criminal appeal. Order sheets. This is criminal case over there.
This one. Order dated 3/6/2025.
Just
No.
100 minutes already. We have already granted.
35.
Should have been separate order sheet for misuse. You have to do this one in the main petition. The order is not passed in the main petition. It should be a separate order sheet for the misuse. Misuse is disposed already. But this appeal has been admitted on 15/5.
My lord.
Okay. Anyway, just take out that miscase order and keep it somewhere else. This order of the miscase you have to take out and keep it. So why it is it? Okay.
Deputy.
List it for admission is admitted. Do not have to list it for admission. You have to list it for orders. Next time you will list it.
May I please, Lordship? Lordship, in this item number 2,
Wait. Let it be gone. Yes.
Right.
Yes.
this connected matter is pending in before the division bench, Lordship, which is likely to come on 9th of July.
9th of July.
It may
So when shall we have it?
After 4 weeks, sir. Let it come after. Come on 22nd or 23rd July, Your Lordship.
So after 4 weeks.
Lordship. After 4 weeks.
So the last order. Same order last 4 weeks.
highly rate.
Yes.
Apply.
Item number 3.
Yes.
Counter documents have not been filed, Lordship, till date.
May it pleases Your Lordship.
Yes.
So far as still is concerned, Your Lordship, we are not going to file the affidavit, Your Lordship.
And what about the respond number? Yes. Yes, Mr. Sangma, have you filed your affidavit?
Lordship.
You do not know about your case?
In this item number 3, Lordship, I'm seeking some accommodation to file my objection, Lordship.
Okay.
Lordship.
Objection in the...
Yes, I will file an affidavit on opposition, Lordship, because I am the private respondent in this particular.
So you're here to file your counter
I
here.
definitely I'll file it, Your Lordship, because
How much time you need?
at least 3 weeks, Your Lordship. I will take it.
Yes, just say, Mr. Shall I learn it? AG appearing for the state submits that no affidavit will be filed on behalf of the state in this matter. Stop.
There is a miscase also, Lordship.
Wait. No, say, Mr. Tisama, Lorna Council appearing for the respondent. Praise for grant of further 2 weeks time for filing counter affidavit on behalf of the said respondent, on behalf of the respondent number 2. Clear allowed. List after 2 weeks. And then what do you say? What is
There is a
miscase?
miscase, Lordship. Miscase.
Okay. So you want this? Yes, Mr. Sama, shall we make this interim order absolute instead of extending it on the?
I made last chance.
Okay. Just say list along with the main writ petition. Interim order passed earlier.
Shall continue.
Shall remain in force. Shall continue with
Yes, sir.
till the next date. Yes.
So, my lords, I believe previously order has been passed. My lords, the interim orders will continue until further orders. My lords.
No, it is not.
So,
There. It is
No,
not.
in other cases. In other
It is in the meantime. It will continue.
cases.
Yes.
Item number 4.
Will be till the returnability, huh? Yes, till the next date.
I'm entering appearance, Lordship, for the respondent.
Yes.
Lordship, I'm appearing today. I'm appearing for respondent number 2.
Yes.
Lordship, matter may be fixed for hearing after 2 weeks.
So there is no requirement of filing affidavit?
I have already filed, Your Lordship.
Affidavit of service?
Yes, Your Lordship.
Okay. You will appear for the respondent number?
2.
And who is for respondent number 1?
And for respondent number 1,
Okay. Just say. Just record presence. Mr. Alice is present with the petitioner. Ms. Lau appears. And Mr. So and so is present on behalf of the state respondent number 1. Then you say MS Lau has entered appearance on behalf of the respondent number 2. So there is no requirement of filing any objection at all. Yes, sir. Next line you said the party submit the matter is ready for hearing. Yes, straightforward. Just after 2 weeks for hearing. Yes.
Obligation, Lordship.
6.
Yes. For 5 and 6. What is to be done? Yes. So what is to be done? What is your prayer to do? And what about the state?
State, my lord, so far as the investigation is concerned, my lord, the case is premature, my lord.
That is okay. Are you filing anything? No.
Oh, no, my lord.
Okay, just say none appears for the petitioner. When you say spread for by MS Jetty Sangma. Yes, London House. You are there for?
The respondent number
5.
5.
So what is your prayer?
Lordship, I won't be finding any objection.
Who is respondent number 5 here?
Lordship, he is the investigating officer, Lordship.
So you will not file any objection. State also will not file any objection.
No, my lord. I'll seek further instructions, my lord, if necessary. Will.
What is this matter about? This is a prayer for?
My lord, out here, my lord, the FIR was filed against this petition, my lord. The allegation is that she had stolen the gold chain and this gold bracelet.
This is a petition for quashing?
Lordship.
No, what is the stage of the matter? Is it under investigation or charge sheet?
No, lord, not it's still an initial stage, my lord.
Not yet charge sheeted.
No, my lord. And recently, my lord, the IO had.
Who is respondent number 5?
Number 5, he's a complainant, my lord, complainant.
Yes, why the police officer?
Sorry, my lord, the sub-inspector.
Why he has been made a party by name?
Because, like, lord, they were saying like he had legally detained.
Okay, there is some personal allegation.
Lordship.
There is allegation against him.
Lordship.
So you are not filing an affidavit?
No.
And you are the complainant?
I'm the husband.
The complainant.
Complainant. That is what. So we will file objection. Okay. Just say, Mr. You will appear for the number 4, Mr. Inja?
1 to 4, my lord.
Yes, Mr. Inja, Learning J appearing for the number 1 to 4. And MS ADCM. Learning Council appearing for the number 5. Submit that no written objection will be filed on behalf of the said respondent. Is required to be filed on behalf of the said respondent in this matter. Stop. Then MS Jetty Sangma, Learned Council appearing for the number 6. Praise for and granted. How much time you want?
2 weeks.
Praise for and is granted 2 weeks time for filing objection.
Team name, Raj.
Item number 7.
Say none appears for the petition, right? Yes.
7.
May it please your Lordship?
Yes.
Lordship, I am under appearance on behalf of respondent number 3.
Yes.
So Lordship, let this matter came out for hearing after 3 weeks.
For what? You want to take instruction?
No, let this matter come up for hearings, your Lordship. For hearing, your Lordship. For hearing.
Hearing? For hearing?
Yes, your Lordship.
This is you will not file any objection?
No,
Not,
your Lordship.
the objection is not required to be filed here, this matter?
No, state will be filing.
State will be filing? Oh, that will be, okay. Okay, then we'll list it. Say that you say the matter is ready for hearing. We'll list it for hearing. Okay. Just say so and so and so and so are present on behalf of the state and the respondents. Then you say MS so and so, Learned Council has entered appearance on behalf of the person number 3. Stop. Give a paragraph. This is a party submit. The matter is ready for hearing. List this. Then you say list this matter for hearing after 3 weeks. Oh, as prayed for, list this matter for hearing after 3 weeks. Yes. Yes.
8.
May it please, Lordship. Yes.
Lordship, I'm entering appearance on behalf of Respondent number 7, private respondent.
What about 6? Okay. And what is... Okay, you are already there. State. So you have to file your affidavit then? Affidavit.
all awaiting instructions.
Okay.
So we'll pay for time.
Okay.
Kindly 3 weeks is granted.
Yes, just say Mr. So-and-so is present on behalf of the petitioner. And Mr. Kapi G is present on behalf of the respondent number 1 to 5. Then you say Mr. So-and-so Learned Counsel enter appearance of the respondent number 6 and Mr. So-and-so respondent number 7. Okay? Has entered appearance of respondent number 7. Stop. Then you say as per by the Learned Counsel of the respondents. 3 weeks time. 3 weeks time is granted for filing counter affidavit in this matter.
Hearing item number 9.
No, please, my lords. My lords, this matter, my lords, have heard at some length. This is the second round of litigation we had come before, my lords. My lords, I am instructed, my lords, on the last occasion a query fell for my lords. My lords wanted to see the prayer of the last writ petition that had been filed. This pertains to, my lords, a certain plot of land in the R&R colony where certain directions had been passed by this honorable court, my lords. And in the course of hearing of this matter, my learned friend was, my lords, addressing my lords. My lords had indicated that my lords wanted to see the prayer in the earlier
previous round of litigation.
My lords.
And what order was passed in that litigation?
My lords, there's a detailed judgment that was passed, my lords. My lords would find it at page 38 onwards, my lords, is the operative portion.
Okay, that is that allotment of...
Allotment, my lords. And thereafter some inquiry has been done, my lords, and it has come. I was praying, if it is not inconvenient to my lords, if this matter could be taken up, my lords, on Friday or any other convenient date, we could probably, my lords, just bring that, may not be by way of an affidavit, I'll have extra copies of the writ petition made, my lords, for perusal of my lords.
Now, this court has basically forgotten for what purpose that was called.
I'll start from the beginning, my lords.
That is all right. That is all right. Like why that was needed. Any order passed?
Is there in the, it's not reflected in the order sheet.
No, not order. In the middle of a hearing, Your Lordship. In the middle of a hearing, what happened, Your Lordship, was Lordship just wanted to see what was the prayer in the earlier round of litigation. Because the limited issue in which we concluded the hearing was, Lordship, whether they have got an enforceable right. Allotment was not concluded in form of an agreement, and so same thing remained uncured in the first round, and it also remained unaddressed in the second round.
My humble submission, my lords, is on the contrary. This honorable court had settled this issue at paragraph 8. There are two parts to the direction, my lords. First was to find out if it at all was allotted, and if it is allotted, my lords, necessary follow-up action should be taken up in accordance with law, which necessarily meant, my lords, we would be relegated to a position where, my lords, the judgment of Honorable Justice A.P. Singh in the R&R colony matter would then come into play, my lords, where there was a direction issued to the government of Meghalaya to issue patta.
That is all right. But then say supposing if it is found that...
If it is not allotted, my lords, I go.
No, see, I don't think that there is any controversy with regard to allotment.
The Lordship is correct.
Whether that was acted upon or not, that is the...
That is the issue.
That is the issue.
That is the issue.
Now, the second part of the direction, if we confine ourselves to that, and you say there is... and if allotted to the petitioner's grandfather, necessary follow-up action be taken up in accordance with law. Now, what is meant by that?
My lords, we would be relegated, which is what I submitted, my lords, we'll be relegated to a position where, my lords, all these lands were regularized and pattas in respect of all these lands were issued by the government of Meghalaya. That was under orders.
No, but then if that allotment was not accepted, then what happens?
My lords, I would humbly submit that that would not be of relevance, because this is the entire case, my lords, that under the scheme, my lords, a certain portion of land was acquired. after acquiring that land, my lords, plots were demarcated and there was allocation of plots under valid allotment letters. Now there is a list of allottees, my lords. Now if there is an allotment made to me, my lords, matter ends there.
No. If allotted, then necessary follow-up action be taken. Now this is the second part of the order is not specific because it was not known to the court at that point of time whether that allotment was acted upon or not.
No, this was the same issue that was urged, my lords, in the earlier round of litigation as well.
Probably that is why we wanted to see the prayer of
My lords, which is why not only the, my lords, writ petition, the counter affidavit, what we'll do is, my lords, just have photocopies of that ready for perusal for my lords.
Now, Mr. Khan, another issue will come probably here. Now, these are the land. It was specifically meant for utilization of displaced person. It was for settlement with for
refugees.
Kind of rehabilitation. Yes. Now, tell us, even if, let us assume that has not been, allotment has not been
acted upon. Accepted.
Yes, accepted upon.
There is a.
How could it be allotted to some person who is not a refugee? Until there is a diversion of that scheme. If a land is meant for the purpose of utilization for certain specific purpose, then how can it be diverted and it be allotted to some person who is not a...
Lordship, the query that is foreign from your court.
Even if you assume, we say that Mr. Paul has no nothing, but then you'll have to satisfy us, how come you allot it? And it was to be, land was basically, I think it was allotted under a scheme of central government.
Yes, Mr. The land was acquired by the central government and
what authority unless you had any permission? Mr. Paul, please see in that line what suddenly comes to the mind of
just taking what fell from your lordship's knowledge, I think the similar issue had come up in Chittaranjan Park and Defence Colony in New Delhi, and that fell for consideration of the Delhi High Court, if I'm not mistaken, where the same issue was formulated. These were for specific purposes that the central government had acquired these lands, and these lands were allotted to people, my lords, under that particular scheme. Because there's money paid, my lords, public exchequer's money was paid. So whether it could be utilized for any other purpose, then it was originally meant for.
Yes, until and unless...
We'll try and place the judgment also.
Lordship, can I just hurriedly try to clarify a bit?
Please, go ahead.
First thing, Lordship, the allotment was given, there is no denial about it. That means the allotment letter was given. So I'll have to qualify the word letter. No, there was a scheme that says until and unless you comply with certain requirement and the engineer will have to measure and take possession, it's not completed. So Lordship, this is very important fact. This has remained uncured, waived. Okay, Lordship, first part is that. Now, the second query, no, if that has happened in the first round of litigation, also the same thing remain. Lordship will kindly see the prayer. That Lordship will get the answer when you see the prayer. The second part, Lordship, what has fallen from your Lordship, it was a scheme meant for a particular purpose under central government scheme. How can land be deviated? Lordship, this was an issue that was in existence since 1954 till 2000 when Honorable Justice A.P. Singh passed an order. Prior to that, the status remained as rehabilitation land. The society from rehabilitation themselves approached the court and said this allotment is creating a problem. Allotment is creating a problem because we don't know, it does not give us transferable and heritable right. Then Honorable Justice A.P. Singh's judgment has occupied the field after that. He directed the government, kindly look for the allottees. Now when I say allottees, Lordship, who has completed the process. So we have two categories. People who have completed the process and still remain allottee, and people who have not completed and who doesn't have possession. Petitioner herein come in the second category. Not completed, not in possession. Completed possession, direction was given to the state, kindly give them notice and ask them to approach the concerned revenue authority and convert the allotment into leasehold land.
That's all right.
Lordship,
but the moment answering the query of the court.
No, Lordship, the moment direction of the High Court, that's why, Lordship, prior to Justice A.P. Singh's judgment, the status remains, Lordship's query remains as it is.
See,
after judgment, it is acquired, Meghalaya government became the lesser, Lordship, after the judgment, and the allottees became the lessee.
Well, it's just taking it forward from where
Where is that part? Where is that part?
Lordship will answer that in the judgment itself.
This
is not my opinion, Lordship. This is what is followed. This is in the judgment itself.
What my learned friend is arguing, Militz, if that were to be the case,
We'll read out the judgment.
it will be a self-defeating argument because of a simple reason. He says, Militz, there are two circumstances where the allotment process is complete, where it is not complete. Allotment process only when it is completed just as AP Singh's judgment comes into play. So that leaves out the second part. Assuming, my lords, I fall in the second part, you have no right to issue any patta. It's a self-defeating argument, so it can't go there. Which is why my lords have rightly said that unless the scheme is modified by the central government, can you allot the land to somebody else?
Probably, of course, we do not know, subject to what you said at the time of hearing. The judgment of Justice AP Singh was confined to the conferment of right and title of ownership, leasehold right and title of ownership on the allottees, those who accept. Nothing beyond that.
Lordship is
we
very
cannot,
correct.
we cannot interpret it to say
Lordship is very
that
correct.
this entire land was given to the state government and so that the state government can use it and allot it to any manner.
No, Lordship. That was not the case.
Never change the status.
That was not. Your Lordship is correct. That was not the case. What happened after Honorable Justice Lordship? We'll have to other time we'll have to read it out. What happened after Justice AP Singh's judgment was that state became the hat was changed from central government's allottee right to state becoming lesser. We'll have to rely on the lease deed, Your Lordship.
This court is not.
Well, that's a contrary position taken by the state in another matter, where they say, well, it's para 20 is not touched by virtue of Justice AP Singh's matter. Para 20 of the 6th schedule, Melons, defines which is the area under the control of the state government, which would fall under the autonomous areas. This is acquired for a certain purposes, Melons, as your lordships have rightly said, only for the purpose of administration. This honorable court said, Melons, issue patta. Matter ends there. Nothing beyond that.
But then, Lordship,
that's the position that
Lordship, then after Justice AP Singh's judgment, who would issue the lease right, Lordship? Unlike cantonment. In cantonment, if we draw a parallel, Lordship, in cantonment, the lease, the lesser, is signed on behalf of the President of India because the owner is central government. After AP Singh's judgment, Lordship will bring on record, Lordship, once we can get the sample of the lease deed. That will speak for itself. I may be wrong, but let us see what does the lease deed says after Justice AP Singh. The state government revenue department has assumed the hat of lesser. And the allottees were asked to come with the relevant allotment number and step into the shoe from allottee to lessee. Now the case, for our present purpose, this is an academic discussion. For our present purpose, the status of allottee since 1954 has remained not as an allottee. His enforceable right never existed before Justice AP Singh's order, neither just after AP Singh's order. So the issue is whether, as per the scheme or after AP Singh's judgment, he has no enforceable right.
No, see, the question of his locus, that remains, definitely.
Enforceable right is not there.
See, his locus definitely remains. The petitioner locus definitely remains a question.
All other issues will come, yes.
That once if he doesn't accept allotment, what right he
that has been a primary argument.
Even if assuming that you do something wrong. Okay, until and unless his right is affected, that is definitely that.
He's not affected.
That's the issue while this honorable court directed an inquiry, Melons, and I'll take your lordships to the inquiry report. What kind of an inquiry was done?
So let him just bring the prayer part for the satisfaction of the court.
I'll have the writ as well as the counter affidavit on record.
Justice AP Singh's judgment is
on record.
Appended.
Lordship, kindly go through the AP Singh judgment in detail, Lordship. Maybe we can assist.
No, you are there to assist. You have to assist. Without your assistance,
I'll try to my best ability, Lordship. I may be wrong, but I'm just trying to assist. In case Lordship needs, we can get a sample copy of the lease deed after Justice AP Singh's order. What was the nature of a lease deed? At least one sample we can get, Lordship.
In that
page
matter before in this matter which was decided by Justice AP Singh, the union was a party there.
Union was a party. And as a matter of fact, this honorable court directs, Melons, that the union government as well as the Assam government should be party to this entire exercise of allotment. Page 27 is the relevant portion.
And if we go to the history of the allotment, how it came to be allotted, do you have any idea about the background?
It's reproduced here. It says, Melons, I'll just very quickly take it.
Package, Lordship, by government of
I'll
for displaced people. There was a scheme.
There was a scheme. We have annexed Lordship in our affidavit.
See, Mr. Khan, if you go through this Justice Quashing's judgment, then what you say will not stand. If you see the last part, now it says if the Deputy Commissioner Government of Meghalaya is satisfied of the rights of the occupants of the land in question. So he was not at all an occupant. What is the question of allotting?
Then it becomes a self-defeating argument. Malaj.
Even if you accept that you had basically...
Lordship, for a minute, if you pause and go back to my original argument, if he was not an occupant, then it's suppose the case of... That means Justice A.P. Singh's judgment will not be applicable in the case of petitioner because his locus in possession is not there.
If you go deeper,
Lordship,
then many things...
Lordship, occupant, for a moment if you pause there, then it's suppose the state theory because he was never an occupant. As his right as an allotee never culminated into in
talking
possession.
about the petitioner, or we're talking about the respondent.
Petitioner. That means, by Lordship, that means A.P. Singh judgment is not applicable in this case.
If it is not applicable, Malaj, then the state has no role to play in respect of plot 267. If plot 267 you cannot play a role, Malaj, then the private respondent goes.
Then Lordship, we go back to the scheme and the argument whether he has got an enforceable right. That we confine back to our case.
Then it would not lie in the mouth of the state of Meghalaya to raise that argument.
No,
Central government would have to raise that
we
argument.
rely on the scheme. Then Lordship, we go back to the primary argument.
Go through Justice A.P. Singh's judgment, refresh yourself and then come back, make submission.
Oh,
I think
okay.
that is better.
But our argument
because you see in this judgment, even you see like the government of Assam and central government also was asked to play some role.
Malaj, government of Meghalaya, if I may say, Malaj, as your lordships have seen at page 27, comes into play only as a successor government. It opens up with successor government. So it will not lie in the state of Meghalaya's mouth to Malaj raise a question regarding my locus.
We go back to the scheme, Lordship. Then. Let us see whether...
When the scheme came in, Malaj, Meghalaya did not exist.
Whether as per scheme of 1984, whether they have got an enforceable right. And then Lordship will... The moment we answer that question, we have to go back to section 35 of the Specific Relief Act. They'll have to obtain a deed of declaration decree from the court. Yes. That is a requirement of law. Dispute question of fact. Possession or occupation is a dispute question of fact. This honorable court cannot interpret
I
this
only
argument.
ask myself, Malaj, then what happens to the orders passed by this honorable court in the first instance? We cannot wish it away.
As per law.
We cannot wish it away.
No.
We cannot wish it away.
If he is found, if he is an allotee, then the court will, then the government will take a decision as per law. Now, as per law, Lordship, it opens up Specific Relief Act, it opens up Civil Court, High Court. The issue is whether disputed question of fact, whether you are in possession or whether the allotment was completed. Can we find from the pleadings? If yes, Lordship, then he has to be non-suited before this court.
It would have to be found in the inquiry report. That is why there was an inquiry.
Inquiry report, Lordship, has addressed the issues, everything in detail.
We'll see that, Malaj.
Everything, Lordship. All the answers, Lordship, we kindly just go through the inquiry report, everything has been answered.
If my lords just permit me two things, Malaj. The judgment of this honorable court came on 26/9/2013. The judgment of Honorable Justice T.N.K. Singh Malaj in the first round of litigation.
2013.
13. The inquiry report, my lords, would find at page 40, my lords, it starts from page 41. 41, my lords, my statement is recorded. And 42, my lords, to counter my statement is the statement of one Mr. N. Bhattacharjee is recorded at paragraph 3.
They've been relying on that part, saying that is an infirmity. We agree. It doesn't affect the inquiry.
If you agree to that infirmity, my lords, nothing survives. Because my lords will say the statement is made on 23/9/2009.
One thing is that Mr. Khan, his earlier writ petition was not rejected because of want of locus standi. So probably we cannot go beyond the order which was passed in the earlier round of litigation.
We cannot wish to. It's there.
Now then we'll just see what is the follow-up action taken.
Lordship will kindly see, Lordship will read the operative part. If the petitioner has been allotted, now that is an issue of law. Allotted. We are arguing only on that.
You say the petitioner was never allotted.
Never allotted. We can raise the issue, Lordship, on the basis of pleadings. And Lordship will kindly give us time. We'll read out detail-wise how it was not allotted. Everything on record. The moment that argument is answered on facts, the locus goes against him. And the scheme has taken care of that. All before the court of record. Everything is on their own record. And that's why my submission is this, Lordship. If you don't have an enforceable right, you can't seek a mandamus. Your right is yet to be ascertained. And that stood evaporated, exhausted, waived back in 1954. And most importantly, in Lordship, neither in first round nor second round have they replied that allotment was completed and they have taken possession. There is no pleading.
We file a rejoinder.
Lordship had asked this question a number of times.
One.
There is no pleading to that effect.
Just a minute.
Please.
Yes, Mr. Paul.
My lords, I was praying my lords may have it sometime any date convenient, my lords. Next week we'll try and assist your lordships with these relevant documents. And also, my lords, that issue that without the dilution of the scheme, whether any successor government at any stage, my lords, can allot the land to some other party. Because the lordships have taken judicial notice of that and allowed, my lords, implement of the respondent number 5 as a party respondent.
Passing observations. These are not.
No, I'm not on that. I'm not on that. I'll have to first establish. I am, my lords, still on the case.
Do not base anything
on the no, my lords, I'm not. I am only saying, my lords, the two aspects. What my learned friend also said, that I've never denied it. There's a rejoinder file that has appropriately been answered. Not only the writ petition, my lords, the counter affidavit also I will bring it on record to show, my lords, whether there has been any change on the stance of the government pursuant to the judgment of this honourable court. And why I say, my lords, that is relevant, my lords, because the private respondent has impleaded himself as a party, saying that I am an allottee of the present state. So therefore, my lords, the second question will also
his
come.
allotment comes much after Justice Appeasing's order.
Much.
2010, Lordship.
Much.
No, that is whether that right was available to the state or not. That is
exactly.
In normal circumstances, my lord would not examine that. But now that he's come, my lords, your lordships will take judicial notice.
Whatever reading, like whatever.
Lordship is correct. That is that
part of Justice Appeasing doesn't appear to.
That does not cover that judgment, provided we accept that argument.
You see, like the process of verification of ownership and thereafter. Did not say that about fresh allotment.
Absolutely. They cannot treat it as their own largesse. Well, the state cannot treat it as its own largesse.
But Lordship, imagine a situation. Justice Appeasing judgment said, just to give a bit of clarity, there was 257. 274 rehabilitation citizens who came from Bangladesh. No, the purpose of Justice Appeasing judgment was, a lot of them had died, some had left, some had sold. So it says, kindly come before the revenue for identification, verification as to who are the heirs. You come with proper
documentation. We can understand there must be a purpose for it, but then we have to go by what meaning it portrays.
So no, in a situation, Lordship, imagine.
We will not give a narrower connotation.
Yes, larger connotation, Lordship. I've just gone through it, Lordship. The larger connotation was, imagine a situation, somebody who was allotted, who has complete allotment package, but he or she died in 1980. And then how would the legal heir come? Now, legal heir, there is no transfer of transfer. That was the purpose of using the word occupant. If the heir is an occupant, in spite of the fact the predecessor has expired, and if you can show that you are an occupant coming from that lineage, by virtue of being an occupant, you are entitled to, and the government was given a responsibility to.
The purpose was to see that
multifaceted, Lordship, multifaceted. That itself is a subject matter, because that judgment was never appealed. In my respectful submission, Lordship, the word occupant here will go against the petitioner, and in fact, it's not applicable in the present case. He has to first overcome whether he's got enforceable right, which he has waived way back in 1954. In both round of contempt.
Which was to be established, my lords, in an inquiry. You cannot absolve yourself of an inquiry.
Does he have an enforceable right?
That is an issue to be decided. That was an issue to be decided in the first writ petition. Once my lords have passed a positive direction, it is understood, my lords, that your lordships have dealt with this aspect and said that let there be a verification.
He doesn't speak.
We'll just see it.
I'll address.
Wait, please, Lordship. For the respondent number 4, Lordship, I filed my affidavit since 2021, July. And Your Lordship, during pendency of the entire proceedings, I have filed an affidavit to bring in record a document, the list of the original allottees to the entire plot in R&R colony, Your Lordship. And Your Lordship, I have filed an affidavit in July 2023, whereby I have relied on the document which I have obtained from the archives of the government of Assam, where clearly it has stated and clearly mentioned the names of the original allottees, has taken actual possession and utilization of those spots allotted to them respectively, Your Lordship. So, Your Lordship, I highly rely on that, and Your Lordship, it's on record, the list that I have supplied with. However, Your Lordship, another point of the entire question and controversy involved. In the pleadings of the petitioner, Your Lordship, they have relied on the Assam Displaced Person Rehabilitation Loan Act 1951. Your Lordship, under Section 4 of the, with respect to grant of loans to the allottees, has taken possession for construction of a house therein, the land allotted. So, Your Lordship, my humble prayer is that this legislation, as of at present, it deserves to be examined as well, this act, so as to bring in the clarity as to the grant of loan, the process of who are the displaced person, and there's a rule appended to the Act 1951, which has clearly clarified as to the value of the loan, how much should be granted to the allottees. This will bring the entire clarification as to the matter of the procedures of the process. Of
What loan has to do here with the...
What is the notification? Assam notification?
What had happened is these plots, Millards, were converted into a loan amount. I think it was 800 rupees. And thereafter, Millards, when the Indira Gandhi government came in, Millards, that loan amount was waived by the central government in respect of the allottees who had been given.
Otherwise, it was for the allotee to return that amount.
And,
so it was not was absolutely free allotment at the beginning. Absolutely. But then subsequently it was waived.
The government of India took a decision, Millards, that it is waived.
So that
it is waived in respect of the allotee, not in respect of the state.
So far the notification of Assam is concerned, Your Lordship.
What state? What is the
notification of Assam which he is relying on, remember, Your Lordship, is that he was never in possession. That further buttressed the argument of the state that they were not in possession. And he is relying on a notification from Assam.
Mr. Paul, so far as the earlier writ petition is concerned, I don't think you have to bring it by an affidavit.
I just have copies.
You just place it just at the time of hearing.
Copies. Not only the writ, Millards, the counter affidavits filed over this would have relevance.
Take note of the thing.
I would have to deal with these things.
Your Lordship, can we examine the list which I have filed?
Definitely we will. See, the problem is that, you see, it is not that this court can decide only on the basis of the list, because there is an earlier round of litigation where an enquiry was ordered. So that we have to see that part also.
Yes,
we cannot avoid.
Lordship is correct. Lordship is correct.
This is my first round of litigation.
We'll have to start off with the inquiry. Lordship is correct.
That is okay.
Yes.
But then the earlier order, you want to say that it will not be operative.
It will be.
Because your state section is under challenge.
It will be, yes. Lordship is correct. Except for the word using of the Banerjee statement in Lordship in inquiry, there's nothing wrong.
If you're relying on a statement, Millards, recorded in 2009, pursuant to a direction in 2013, it itself shows the perversity of the inquiry.
It means very purpose of the inquiry is defeated. That means it gets defeated.
Because I will be filing a writ petition now, and I will be referring to the Millards counter affidavit filed by my learned friend in the earlier round of litigation. Is that permissible in law? Absolute non-application of mine.
There's a straight statement.
But then that theory will not apply.
It doesn't confer him the right of allotment. How? I can imagine if it deprives him of allotment, then he has got a case.
It was just an instance, Millards. I cannot treat it as a counter affidavit in this writ petition. I can rely on it. I can say, Millards, that in that I have made this statement.
Which was relied upon,
Millards.
It was given in context of what?
Who was in possession of the land from 1950? Lordship is here.
I don't know.
Lordship is here.
Millards, I don't know.
Just let him say.
I don't know, Millards.
No, I know, Lordship.
Where from that statement came, it was placed before the inquiry officer.
We don't know, Millards. Report is silent.
Lordship, that statement.
You have a record of this.
Lordship, yes. Lordship, that statement was basically given by some ad hoc secretary of that area. While in the first round of inquiry, which
where? In connection of what proceedings?
In regarding to position.
No, but then the thing is that
before 2010.
Thing is that if his statement was to be relied on in an inquiry, would it be proper?
Document,
without affording any chance.
Chance was
the
given.
other side.
Lordship, chance was given.
No, it's we can't make statements off the cuff.
Lordship, for a moment, That statement is neither here nor there. It doesn't add to his case, neither it extinguishes the case of state because it has got no relevance with the allotment. It was only with relevance to possession.
So you want to say that the inquiry was not based upon that statement?
It doesn't affect. It doesn't affect. Had it eclipsed his right, then his right to hearing would have to be taken care of. It doesn't. It doesn't give him. 1954 is governed by scheme.
Then what is the purpose of my lord's recording
Lordship
his
satisfied.
statement?
Lordship, kindly go through the inquiry in
That is
detail.
in the
I ask myself these questions, but I don't know.
Holding of inquiry became mandatory because there is judicial order.
My lords.
Yes.
So you have to see that.
Yes.
That is.
And how does it affect? Taking care of it or ignoring care of it, how does it build up his locus case? It doesn't.
I am saying, my lords, that if you are considering some documents, my lords, which are absolutely no relevance to an inquiry, it vitiates the inquiry, entire inquiry.
Let's satisfy Lordship. The principle of prejudice.
So we'll have it after
a week.
After a week, will be possible.
Any date convenient to my
Any
lords.
day, Lordship. We are
All right, no, Robert told. Therefore, otherwise 2 weeks. Just see.
Otherwise, normally court fixed 2 weeks. Because next week, sometime we always have a fixed matter. So.
After 2 weeks, it's only.
हमको याद नहीं रहेगा क्या क्या बोला तो आप
No, you can. Variation. After 2 weeks, it can be 15 days, 16 days. Also.
So they
Just a request made by the. On joint request made with the parties. This is met after 2 weeks. We are not saying anything. You just produce.
Yes.
The copy of that earlier.
Xerox copies are okay, Lordship. For us, we don't need affidavit. Yes.
Obliged. It will come after 2 weeks.
Let's hope he is there.
It will come after 2 weeks. It can be on 14th day, 15th day, or 16th day, depending on the.
No issue, Lordship.
15th or 16th, 14th is a holiday.
That
15, 16.
We are there. Much only.
11.
This is an application under section 482. Limited issue is, my lords.
What was the instruction to be taken?
Lordship, with regards to the
How's the
status of the case before the
trial has not proceeded.
What is the stage? It has not proceeded means like
It is, my lords. It was at the stage of framing of charge, my lords. It still continues to be at that. Charges have not been framed.
It is almost 8 years.
8 years, my lords.
Is it correct, Mr.
Lordship, I have to seek instructions, Lordship, with that.
No, why it is like that?
My lord, I think it's because of.
It will be clear, my lords, if I just place the case. What had happened, my lords, is there was an FIR under the Drugs and Cosmetics Act.
May please, Your Lordship. If
Then
I
what
can-
happened is, my lords, at the stage of argument before charge, the public prosecutor, my lords, started making a submission saying that it should be not under the Drugs and Cosmetics Act, it should be under the NDPS Act. We had, my lords, raised an objection that the FIR in the first place itself could not have been made out in view of the bar under section 32 of the Drugs and Cosmetics Act. The trial court, my lords, takes a view saying that I have the power to alter charge, and, my lords, in the penultimate portion she says that hence fix so and so date for framing charge under NDPS Act.
Where is that order?
Well, I'll take your lordships. Well, it's at page 40, last line. I'll just read another page, Millers, that would be relevant for us. Page, if my lords first have page 37.
Yes.
Well, I'll start. The sentence starts. The defense only made argument on the alteration addition of charge under 216, which will arise only after passing the stage of section 239, 240 CRPC. However, in this instant case, court has reached the stage after giving both the parties the chance of hearing and after perusal of the materials on record, basing upon which this court is not bound to go by the section of charge mentioned in the charge sheet, but in event found that such charges are permitted, as per materials on record needs to be framed, then the court may proceed to frame the charge if the accused is presumed to have committed such offence triable by the court, even if such charge not mentioned in the charge sheet, and for this view is specifically reflected also in the ruling cited by the defence at para 2. Therefore, to his first citation, this court found in this case that after investigation and for materials available on record, a case is made out under section 21 of NDPS Act instead of section 27AB2 of the Drugs and Cosmetics Act. Second citation of the defence is irrelevant. And then, my lords, page 40, if my lords kindly go, it says, hence the charge, last line, my lords, of the order. Last line, huh? Hence the charge under section 21 NDPS Act will be framed against the accused persons when all will be present. That's where the matter has rested since. Matter could not have been charged under section 21 millets of the NDPS Act because admittedly the petitioner is millets a licensed pharmacy millets, having a valid license which we've also brought on record before your lordships.
That is all right. But then so far as alteration of charge is concerned,
that stage has not
there is
reached.
a provision, isn't it?
My lords.
Probably 216 here.
Yes, my lords. 216 will come, my lords, only when charges are framed. I'll place the law on that.
So, how, which way? This is an order
at the stage of my lords arguments before charge. In the first place, my lords, the court could not even have taken cognizance of this matter. That is my case before your lordships. There's a bar under the Drugs and Cosmetics Act. So when we pointed out the bar, my lords, a plea was taken that it should not be under Drugs and Cosmetics Act, it should be under the NDPS Act. That also is not maintainable, my lords, because of the simple reason I'll place the law. My lords have held that first is the stage of cognizance. If you take cognizance, my lords, at that stage, you'll first frame charge. After framing charge, if my lords, on the basis of the materials available before the court, if the court is of the view that no, charge is not under this section, it should be under this provision of law, then the question of alteration or addition of charge comes.
Oh, that also requires some formalities to be followed.
My lords. The prerequisites of the other provision, my lords, would then have to be followed. In this case, my lords, the basic issue, my lords, if I may just very quickly take your lordships, my lords. Very quickly, my lords, may I kindly come to page 20. This is the FIR.
Please, Lordship, before my senior starts, Lordship, if I can bring your Lordship to status of the case, Lordship, why it may have been stalled, Lordship, because by order dated 8, 10 and 15, 11, Lordship, there was a stay or interim order which was passed by the court, and if I'm not mistaken, if subject to corrections, Lordship, maybe the court below might have stayed the proceedings because of this. Okay. But then, Lordship,
the fact remains that it has not proceeded.
It has not.
That is an immediate situation.
But then,
there was some interim order passed by the Honorable Court at that stage.
At that stage,
I'm sorry, I'm not been able to assist your lordships with that because we are the change counsels in this matter. Originally, Mr. Kaur was, senior counsel was handling this.
Submissions and everything were concluded, and written submissions also were about to be submitted at that point of time. But then,
before this court.
No, Lordship. This was before Justice Dingo.
Okay. So if it was heard by that bench, why it is before this court then?
As it accused. Well, I think there's change of counsel and then there was some gap. That's why probably the matter was released. Issue is very simple, Millets. If my lordship just give me 5 minutes, I can.
Very simple to you.
No, Millets. I was equally confused when the matter.
It depends upon level of understanding. You have to see.
Millets, I bow down. I withdraw my.
No, please.
My lord, if
this.
Millets, at page 20.
You are ready?
No, Lordship. I've just received the brief this morning, Lordship. If I can get some time, at least 2 weeks time to prepare.
The senior counsel is ready here.
Subject to Lordship and the senior counsel.
Yes.
The court, Millets. I can't say anything. Issue is, Millets, that FIR is filed by a sub-inspector. The mandate of section 27 of the Drugs and Cosmetics Act says, Millets, that all offences, other than it is classified as a cognizable offence, Millets, are non-cognizable offences. And there's a bar on cognizance. It says, Millets, it has to be by an inspector or by any gazetted officer, Millets, who's specifically authorised in that behalf by the concerned government, either of the state or the centre, to, my lords, initiate prosecution under the Drugs and Cosmetics Act.
There was no argument held before framing of charges.
This is the order of argument of framing of charge, my lords. That issue has not been dealt with. That's by very objection. We said that this court could not have taken cognizance in the first place. Because the mandate of, my lords, the Drugs and Cosmetics Act, it puts a specific embargo. Only in these circumstances, my lords, a court would then proceed to take cognizance of the matter and proceed to frame charge. Being faced with that, my lords, that's when the argument of Section 21 of NDPS Act was raised. But a plain reading of Section 21, my lords, of the NDPS Act would not be attracted in this case in the first place. On admitted facts.
Just you don't know by yourself. This one. This one. Yes. It doesn't get
You've carried on.
Yes, what shall we do?
My lord, if this matter can be taken up on, give me some time.
Have you seen the record? There appears to be a written argument
My
filed
lords.
on behalf of the petitioner, but then it was filed by previous counsel. Now,
Go on
will you adopt the same thing?
Well, I'll have to just
Please check it. Please verify.
I'll accept.
Otherwise, if you find that this fresh argument is,
As long as there is no contradiction, I'll just have a look at it.
if there is any addition also, then it has to be. Once there is a written argument,
Once it has come on record, my lords,
then
it's
it
my
has
duty.
to be.
I'll have that done.
Just please check it if you have a copy in your file, or maybe
We don't have it in our file, my lords. We'll do that.
Yes. When can you be ready?
Lordship may grant me 2 weeks time to prepare, Lordship.
Yes, Mr. For 2 weeks, all right for you?
Yes.
And the prayer, one prayer made by Mr. Karunang and GA, not GA, or additional PP.
Additional PP, Lordship.
Not objected to L&S Senior Counsel appearing for the petition. I'll list this matter for 2 weeks.
I'll oblige.
Much obliged.
15.
If Lordship, this is item number 15 and 16, Your Lordship, I'm saying this. Lordship,
Let us
I'm
see.
seeking your indulgence to
Give
have
me,
this matter.
Let us see what are the orders in this.
Let's say three order is there, Lordship.
Wait. Just a moment.
Lordship, Miss Case 123 required to be disposed of, Your Lordship.
So far as the writ petition is concerned, the last order says, on the request of Mr. P.T. Sangma, the matter stands adjourned to 2 weeks.
Yes.
Now that is the last order. This is a WPC 2 of 2023.
23, Your Lordship. There are 3 miss cases, Your Lordship, in that. In item 15, kindly have miss case number 1 of 23, Your Lordship. Take out that.
Just a minute.
That is for.
Just a minute, Mr. Shulai. 1 second. Let us find out. Okay. You are referring to 1. Yes.
Lordship, that one, Your Lordship, 1 of 23, Your Lordship, that is for stay. Stay has already been granted in miss case number 5.
In 1, there is no order.
No, Your Lordship. So
no order has been passed.
Lordship, then it has to be
remained
disposed
dormant,
of,
and it is remaining dormant.
Lordship, yes.
Then
miss case number 2 of 24, Your Lordship. This is an application for implement of the Lok Ayukta, Your Lordship.
Yes.
Lok Ayukta. So this also, if the petitioner has any objection or not, I do not know for implement the Lok Ayukta. If
This one is filed by me, Lordship.
No, this is a matter, this is filed by you, application is filed by you.
yes, by the
Objection was filed here,
They have not filed the objection to it.
in that miscase 2 of 2024.
No.
We have filed, my lord.
You have filed?
Yes, Manoj. There is, Manoj, our objections are there in miscase
then
number
that has
2
to be
of-
heard. If objection has been filed, then this has to be heard, Your Lordship. But so far, one Lordship, this
Just a minute, Mr.
required to be disposed of, Your Lordship.
This is miscase 1.
One by one, Lordship.
Just
Yes.
a minute. Order was
So that
been
is
passed in miscase number 1 and then miscase 2. Now miscase 2,
miscase one, Your Lordship, that is for stay.
no miscase 1, no order has been passed.
No,
so
no,
anyway,
then,
just
Lordship,
remain.
this is required to be disposed of, Your Lordship.
Now,
Since the interim order has already been passed in miscase 5 of 24, Your Lordship.
now again, where is the objection filed in miscase 2?
Please take out miscase 2.
When this objection was filed?
On the 6th of December, my lord, 2024.
We say that 9/12 it says respondent number 1 and 2 have already filed their objection. You are respondent number 1 and 2. Who is respondent number 1 and 2?
Lordship, in the miscase filed by Mr. Samak line, the writ petitioner will be the opposite party.
Yes, so respondent number, it has been recorded here as respondent number 2. 1 and 2 have filed their objection.
Lordship, that means the writ petitioner. It should have been opposite party, not
Yes, so, but then where is that objection? Objection is here.
It's dated, Manoj, 6 December 2024.
Any objection? There is no objection. We don't find any objection in miscase number 2. But in the order sheet says it is reflected in the order. Order dated 9/12. Just see. Probably it is on the basis of submission.
Do you have that miscase 5 or miscase 2? 2. Well done.
Yeah, this one, I think. Objection to, yeah, that one is there.
King's Club.
See? Okay, this is gone with miscase number 1. Should be done with miscase number 2. It should be miscase 2.
Why do you write 6 when it is
What is this miscase number 1? What is this? This one?
in Agustin Marang? This is, this is the second case.
No, it has become a problem now. No, it has become just like an office that where you have to. No, that is 6/12. What you have filed? 6/12. You have filed a. This is a
Because we have reply.
in miscase 1.
No, Milord, it is reply in miscellaneous writ criminal number 2 of 2024.
Your, see, there is a reply dated 6/12/2024 filed by you.
Reply filed on behalf of petitioner respondent in MCWR criminal number 2 of 2024. Filed in WPC criminal number 2 of 2023.
Yes.
Oh, which date you filed?
Well, the even the notary Milord's description on the first page says 6/12/2024.
See, there is a, it seems there is a problem in your reply, mister. In your reply on the top, you have given miscase Division of 1 of 2024. And if you come to the contents part paragraph, you have written the miscase number 2 of 2024. Now that is why this has been landed up in different file.
Well, I apologize if that
Is a
mistake has
problem.
been done.
See, until unless you do it, there are so many cases.
Yes, Milord, I understand.
No,
Milord.
see, this has
As
to be
far as
treated
even
it has
my
to be
copy,
corrected
Milord,
here.
it is. I have only the second page, so I'm.
This is something new.
Then my friend Milord can correct that aspect, Milord, so that there is no confusion.
Mr. Sangma, you have a copy of the objection?
This is correct. I think this is correct, Your Lordship.
This one is,
Yes.
actually, I have not received this copy. This is
Miscase number
let him send the fresh copy because I got
24, Your Lordship. Yes, this is the correct.
You got the thing? Yes.
Corrections, my lord. My apologies, my lord, for the...
You have to correct it. Have you corrected it there? You have to correct the number then. Or what is to be done? Or it has been in the office. What is to be done? Can it be corrected like this? Or it has to come this because this has been filed in number 1. You file a fresh because this has been taken as a reply in this. Or it should be treated. We do not know what is to be done.
This one is.
How do we correct it?
Because there was some argument also on this reply, so I believe the parties have taken. I have understood that this is the reply that we have filed to application of impleadment, and in fact, Mr. Jindal had appeared on behalf of the Lokayukta as well on a subsequent date. So, in that sense, this reply can be treated as a reply in miscellaneous case number 2.
Here you have written 2. Here you have given number 2. So it will be kept in that file, in that other file. You just treat it as reply in that.
Lordship, kindly first take up that miscase 1.
Miscase 1, there is nothing, Mr. Shulai. There is nothing, no order passed, nothing. Oh, so it means it's a reply in 2. Okay, so it will go to the file cover. You will change it. You will make it number. This will be reply in miscase number 2, not in 1. Isn't it? There are 3 miscases. Just check it. So right now we are with WP only, 2 only. In WP2 there are 3 miscases, isn't it? Just see the cause list. So reply has been filed in miscase number 2. So it will go in the record of miscase number 2, not in miscase number 1. See the file cover. You have written miscase number 1, isn't it? You have to correct it. It is because of them only, because they have written wrongly. So because they have written wrongly, so this will be. You just see, since there is no judicial order in miscase 1, Since there is no judicial order in miscase 1, it can be treated as a reply in miscase 2. So you just change it. Change this. Okay, it will be miscase 2 and bring it to the record of miscase 2. There is no reply needed in these things. Okay, then what about miscase number 5?
This case number 5, that is a stay application, Your Lordship.
Okay, that is where we have granted stay, isn't it?
Lordship, Lordship, that interim order has
By
been
the order dated
filed.
9/12.
In view of the order,
miscase number 1, no, it is not required to be
not required, Your Lordship,
You
because
just say
there
in
is
mi-
an
you
order
just say-
passed in miscase 5.
Just in miscase 1, you just say,
Lordship, yes.
in view of the order passed.
Yes, Your Lordship.
Order dated.
First order. What is the first order?
This is something. This should have been pointed out, Mister. This is a problem, Mr. Shulai.
No.
There is only one order, isn't it?
Lordship, yes.
Now, in the miscase number 5, there appears to be only one order that is passed in 9/12, and subsequent extension is made in.
Extensions below have been the orders have been passed in the main
In the main writ petition, Your Lordship.
Yes.
In the main writ petition.
This is a problem. It is going like this, undetected.
And I think also that Lordship in the main writ petition, that order interim has been made until further order.
Yes. Well, order dated 16th May
You just order dated? Yes, Mr. Pandey.
16th May, my lord. 16th May 2024.
16th May 16th May. Okay. So that means miscase number 1 and 5 we will just dispose of.
Lordship, yes.
We'll say, Mr. Panda, that in view of the order passed there in these things, this doesn't remain for this thing.
Lordship.
Yes, Lord.
Because there was already an order passed in their main writ petition extending the interim order until further order, Your Lordship.
Anyway, just say right in miscase number 1 and miscase number 5 in those cases. Do it carefully. This, you see, you should point out that there are miscases and order sheets are there. You just say in view of the order dated 16/5/2025 passed in writ petition number 2 of 2023.
Please, Lordship.
By which the interim order dated. By which the interim order. This is there. There appears to be some mistake. You see, like this should not have. It becomes difficult now to cover up things.
Please, Lordship. I supposed to file an objection to the because miscase filed by.
Already, see, in the main case already passed. Where is the question of filing objection now?
No, because
you file it. You file. We will decide this thing.
Lordship, because this interim order was passed after only when the writ petition was the main.
See, this order passed in the writ petition was in your presence, not in your absence. The day on which this order has been passed until further order, this interim order extended until further order, you were present here. So there is no question.
I was there, but on the day I asked, I requested Lordship that I
whatever. See, we cannot. Whatever you did on that day, we do not know now. The order sheet speaks for ourselves when we will go by the order sheet.
No, that
see,
they have filed a miscase.
There is no kind of assistance from the council. See, otherwise this thing would not have happened. Just see, you just one thing. Just write order in miscase number 5 of 2024. Just miscase number 5 of 2000. Just write say. Just say. Just say there's an interim by order dated. Just say by order dated 9/12/2024. Interim was passed. keeping in abeyance the further proceeding of special PC case number 2 of 2023
And then this
till the returnable date. However, it appears from the order dated 16/5/2025 passed in WPC number 2 of 2023, the interim order passed earlier
has been made absolute.
was directed to be continued until further order. Just then paragraph just in view of the passing of the interim order dated 16/5/2025, this case requires no further consideration. Stop. The same shall stand disposed of accordingly, and the same is disposed of accordingly. Okay, this goes miscase number 5, and the miscase number 1 you just say, in view of the order passed in view of the order passed in order dated today's days, it passed in miscase number so and so, this application does not survive for consideration. And the same stands disposed of. Okay. Then
miscase 2, Your Lordship.
Come to miscase 2, where this application for impediment is there.
To write this dispose of.
Yes, there is no order passed after order dated 6/2/2024. See, you should always point out that there are miscases. Nothing is that. Yes, what do we do with this? You will file objection here. Who will file objection?
File an objection.
Okay, then when shall we hear it?
Once they file it. When they file it.
In pursuance of this
objection
application will.
The objection which you found now, this will be in this case, too. Yes, this. Yes.
In pursuance of this application, even
is supposed to file an objection.
One minute, Mr. Pandey, 1 minute. Yes.
Here I have filed an application to implead
Yes.
the lockout. Now they are supposed to file an objection if they
have already filed the objection. Now you say you do not hold a copy of this.
No, I don't have.
Please
Let them supply the fresh copy.
And then you'll just see. Okay. In this you said miscase number 2 of 2024. This. Yes, Mr. Pandey, you are saying something. Yes.
Milos will supply a copy. That
Yes,
is
please supply. And then you'll have it. Yes. You just say. You are filing any objection in this matter, in the miscase? Yes, you are sought to be impleaded here. So what is you are not filing any objection or anything? You will not file anything.
I'll take instruction.
So what shall we say? Yes, just say in the miscase. You just say since an objection has since been filed on behalf of the respondent number.
Should be opposite party number 1, Your Lordship.
It should be opposite party number 1. Just say it is submitted that an objection has already been filed on behalf of the opposite number 1 and 2.
Yes.
We just say Mr. Renja, or we will ask Mr. Pandey's name. We do not know whose name should be. We will record Mr. Renja's name, Mr. Pandey.
yes, Milos.
Yes, Mr. Renja, Learned Counsel. Mr. Ranger, Learned Counsel appearing for the opposite party number 1 and 2 submits that an objection on behalf of the said respondents has already been filed. So, however, Mr. P.T. Sangma, Learned Counsel appearing for the applicant, submits that he has not received a copy of this said objection. Okay. You'll supply?
Actually, on the last occasion we had supplied and we
Anyway, supply it again. Let a copy of the objection be supplied by the Learned Counsel for the opposite party number 1 and 2 to the Learned Counsel for the applicant. When shall we have it?
After 3 weeks. After 3 weeks, my lord.
After 3 weeks. So it seems you are not in a hurry. Okay.
No,
No problem. No problem. Okay, let's wait for release this matter after 3 weeks.
3 weeks. In fact, it would be reply on behalf of respondent number 2 because we are representing Sanjay Sangma in that application. So
No. See, this order is passed in this miscellaneous application 2 of 2024. Why you are opposite party? Why you are OP1 and 2?
OP1 and 2, yes.
OP1 and 2. Yes.
Okay, so
Yes.
this is not order passed in the thing.
Right, I got confused.
See, the entire code is confused. The entire situation here is confused. Everyone is
I
confused.
apologize.
They have made it confusing, Your Lordship.
Yes, it has become.
This is primarily because of us. See, we have not verified the things properly.
No, it is our responsibility also.
See,
To
anyway, then just say as straightforward the parties. This is matter after 3 weeks.
Yes.
Okay, in the miss case. Now come to the remanded petition. Just say list this matter along with list this matter after 3 list this matter along with miss case number 2 of 2024 after 3 weeks.
Gotcha.
Please. So 1 and 5 is disposed of. Okay, just take a note of these things. And then 2, this order, and the writ petition, this order. Others, do not make confusion. There is, if there are order sheets, then it has to be just passing on order. Yes.
I may just mention one aspect because since parties are almost, the councils are almost identical in item number 3, Milords, the order dated 15/5/2025 had also made the interim order until further orders.
Which one?
Item 3, Milords. Which is
already, that is different, Your Lordship. There I have not filed even the my objection.
No, I'm not saying that. I'm saying that the Milords, the miscellaneous application, even in that case, Milords, thereafter, Milords, in the main petition, the interim order was made absolute.
In item 3 also?
Yes, Milords. Yes. Just for the consistency of the orders.
Okay, we'll just check it. We'll check it later. We'll just see what is to be done.
Yes,
this because since it has already been called, order has been passed. So we'll just see. Or otherwise, we'll correct it on the next day.
Yes, yes.
Then 16.
Please keep a note on this thing, Miss Kijan. Yes. What is to be done?
Lordship, item 16, I am appearing for the petitioner. In this matter, Lordship, we had filed the writ petition, criminal being number 6 of 2023. Along with the writ petition, we had filed miscase, WP criminal number, MCWP criminal number 3 of 2023. In this MC criminal 3 of 2023, an order dated 9/12/2024 was passed, Lordship.
Interim order.
Interim order 9/12/2024 was passed in MCWP criminal number 3 of 2023.
So saying here also, no, this is just a minute. There is a miscase number 3. 3 is for implement,
Yes,
isn't it?
Yes, Lordship. There are 2 miscase number 3, Lordship, in this particular case. This is 3 of 2024.
Now 3 of 2024 is with regard to the implement.
Implement, Lordship.
Lordship,
And MC number 6 of 24 is again a stay application which was filed by us on 9/12/2024. So no orders have been passed in MC6.
Wait just a minute. Just a minute, madam. Just we are just sorting out the files. This is something terrible. What is 3 of 23? This is 3.
Check the order here.
These are not kept in order. What is this miscase number 6, madam?
That is also
6
for
of
stay,
24
Lordship.
was a stay application, Lordship, subsequently filed in the month of December 2024. So this can be disposed of in light of the order passed.
Just a minute. Just a
in
minute. Have we passed any order in that one? Whether there is any
in
order?
case 3 of 23, Lordship, an order dated 9/12/2024 has been passed.
In that is 6, miscase 6.
Miscase 3, Lordship.
No. Where is? What about miscase 6?
Miscase 6, no order has been passed, Lordship.
That is a case praying for
Stay, Your Lordship.
stay.
Stay, Lordship.
And then
Stay, Lordship.
in which matter interim order is passed? In which case?
MC 3 of 23.
Miscase 3 of 2023. Then why this miscase 6 is filed again?
Lordship, 6 was filed on 9/12 and on that very day the stay order was passed. But instead of passing in miscase 6, it was passed in miscase 3.
It should have been in miscase 6, isn't it?
Yes, Lordship.
This is a problem with our office. All are, see another fault. This is a big
Miscase
problem.
6, Lordship, in miscase 6, no order. The interim
These are-
order has been
otherwise,
passed.
both the matter pertains, both the things pertain.
Yes.
These are this miscase 3 and miscase 6.
3 and 6 relates to stay, Lordship.
Relates to stay.
Lordship, yes.
Both relate to stay, Lordship. It was passed in miscase 3.
So miscase 6 will
And then-
dispose of.
Lordship, yes.
Okay.
Yes, Lordship. In fact, miscase 3
Check.
can also be disposed of
Just-
because
yes, just
by
like-
order dated 9
Six.
interim order has been made absolute.
Yes.
No, when
You
did
do
the
one
order
thing.
made absolute? Yes.
In that order passed in miscase 5 earlier, in earlier thing. Same order you pass here in miscase 3.
Lordship, the dates will change. The interim was made absolute on 9/6/2025, not in the month of May.
Here interim was made, but then interim was made absolute by passing an order in the writ petition, isn't it?
Correct.
Yes, Lordship, in the writ petition.
Check the thing. This has become a mess. See.
It was in the writ petition, order dated 9/6/2025.
This miscase, no, Rosie. Don't mix together here.
Yes, 9/6/2025.
Separate file.
So here only the order, just check, compare it with this thing, and the date of order will change. And writ petition number also will change. Okay? And then that means by same order this 3 gets disposed of. Okay? Then along with 3, 6 also. 6 also.
Dispose
This
of.
case number 6 will be disposed of
Go.
by passing the similar order like 1 in that another one, miscase 1 in that other case. Okay? Only just there will be change in the case number. Take note of those things.
Don't mix like this.
And then writ petition also
Fine.
the same order
Miss-
like earlier before. It will come after 3 weeks. Yes.
Lordship, implement petition is also there. Miscase 3 of 24.
Implement petition
That is miscase 3, Your Lordship.
miscase 3 in the present matter, isn't it?
No, 3. Yes, 3. 3 of 24, Your Lordship.
Here in the present matter, isn't it?
Yes. Yes.
Here,
3 of
here
24.
also this thing you have filed your.
Yes, Lordship, objection filed.
So there also there will be same order like before in that other case.
Yes, Lordship.
That means other case it was miscase 2. Order is in the previous case it was miscase
Yes,
2,
Lord.
isn't it?
Lordship, yes.
So this one will be same. Only the
Like
case
in
number will be
miscase 2 of
And
24.
the date of objection maybe. Okay, or maybe just check it if there is anything written. Okay, and then writ petition also will be same order.
Same.
We will restore it. You got it? Any confusion, you just come and solve these things. Yes, we'll have to come after 3 weeks then. All this matter.
Lordship, it may be fixed on the same date because these are connected matters.
Yes, this will come up with same day. It will come up within the previous day. Yes.
Apply, Your Lordship.
3.
Did you apply, Lordship?
This is a mess. You see, this files and order sheets and all should be kept together, and then this will.
It should be in a separate file.
This is a problem, I can understand.
This item 3.
It is you point out where these miscases are there. That is your duty to point out. Yes, what is this?
3. This is also released to Lok Ayukta, Your Lordship.
So here also.
So
as
that
per-
miscase also will go
Where is
because
Mr. Pandey? Asha.
he disappeared.
Here also he says that
Number 3. Yes, my lord.
Oh, you are there, Mr. Pandey. Yes, you said something about the item number 3.
My lord, in this case also, the order has been passed on 15
We cannot
5
see you.
2020.
Your vision
Yes,
has
my lord.
gone anyway.
Yes, my lord, just a moment. So, my lord, 15 5 2025, the order has been passed, my lord, in this case.
What happened, like this continuation of the interim order is recorded in
Yes,
the
my lord.
case, and that is what the problem is.
Yes, my lord.
This is
So,
our-
on 15 5 2025, a confirmation of the interim order has been made, my lord.
Okay, until further orders, 15.5, isn't it?
Yes, my lord.
Just
Dispose of.
yes. In this case, there is no implement application, isn't it?
No, my lords, there is no
Yes,
implement
yes,
application.
yes. The miscase number 1, just say. This was for you also to
Lordship,
point out, Mr. Pandey. You see, once it happened.
Because I apologize, my lord. It is our responsibility to have pointed out this aspect.
That these
And,
orders are wrongly passed
yes.
in that main case.
Yes, yes, my lord,
Anyway,
yes.
just say, write in miscase. Miscase 1 of 2025. You say, just say. You just say an interim order dated 3/3/2025 was passed in this matter. Suspending the further proceeding of the special PC case number 2 of 2024 till the irreturnable date. Which was just stop. Just give a full stop. The interim order passed was extended from time to time by various order passed in this application as well as in the main writ petition. Stop. Then next time, just say on 15/5/2025 by ordered on 15/5/2025 you just say by order, just say by order dated 15/5/2025 passed in WPC criminal number 1 of 2025. The interim order passed earlier was ordered to continue until further orders. Stop. Just give parenthesis in view of the above. No further order is called for in this matter, and the miscase stands closed. Okay. And then in this writ petition, we have already passed this order We do not know what order was passed in the main writ petition.
This was for time
Okay.
to file the affidavit, Your Lordship.
Oh, okay. What order was passed? Anyway, whatever it is, it is not required to say interim order passed earlier shall continue because already. Yes. Thank you.
Will come after 3
My
minutes.
lords, oblige, my lords. Oblige.
Apply, Your Lordship.
21.
Very difficult time in this. Give the rest, my lord.
This is an application under section 482. In number of occasions, my lord, the private respondent herein has seek time, my lord, to file an objection.
Yes.
And one pretext or the other, the matter was adjourned.
Yes.
And it appears, my lord, the counsel was changed.
There's a change of counsel.
Yes, there was change of counsel.
This objection has been filed here.
We will not file, we'll proceed
Yes.
with.
That we have recorded that the objection is not fair to be filed.
No, my lord, it has not been recorded. But only thing is this: can my friend appear in this matter without filing a wakalatnama? Number of occasions, my lord, my learned friend has seek time without filing the wakalatnama. My lord, this is what I've been instructed. But my learned senior from Rajasthan, my lord, that the wakalatnama has not been filed by my learned friend. And in number of occasions, she has taken time. Whether she has some personal interest on this matter or she is appearing for the client, my lord, that is what, my lord, we are very confused. This is the website report of the High Court, my lord, where her name is not reflecting even.
No, that is all right. If she has filed or not, that's it is not required to. You see, you have not filed your power, madam.
Lordship, the power is, by mistake, my power is here,
You please
Lordship.
file it. We will not take up this matter until unless.
Now, my lord, I have further instruction, my lord. Even if my learned friend filed the power, I don't know whether the power is from the private respondent or not. I was instructed by my learned senior, my lord, the private person has expired.
You want an inquiry to be conducted by this
No, no,
court
no.
on this thing?
No,
Are
I'm
you
not
doubting the conduct of your counsel.
I'm not saying this, my lord. What I am informing this honorable court is this, my lord. The private party, my lord, has expired. I was informed by my learned senior.
it?
Yes.
When?
On 29th of this month. Last month, my lord. Last 29th, my lord. This month. So now, if today, if my learned friend filed the
Today
power.
is fast. This last
Today is
month
first.
June.
Last
Yes.
is June, my lord.
29 June.
29 June. That has been, I have been instructed, my lord. So now, even if my learned friend filed the power, my lord, whether that will hold any water, my lord. That is what I'm trying to point out. It's not that, my lord, I have any.
I have to, because if might be the party is in bereavement and I has not communicated with me to me.
That is all right, we can understand. But then the real difficulty will be that what Mr. They points out is this: if you file your power, that will be taken into record only on today. Now, how can a power be filed after on behalf of somebody who is no more?
Lordship.
And my friend should have filed the power. Without filing the power, my lord, she has mixed.
No, but then what is the effect of this thing? Demise of the respondent here?
No, there is no in connection with the litigation. There is no problem, my lord, because she is the complainant. She lodged the FIR, my lord, against me. But only thing is this: can my learned friend?
No,
appear
but
the-
then so far as this case is concerned,
my lord,
what happens? So far as the complainant is concerned,
my lord,
can a dead person continue as a respondent in the case?
No, my lord. According to my understanding, no, my lord. That is what the problem is. This, my lord.
No, then in such a case, you will have to drop that person.
Yes, my lord.
Lordship, there is some in otherwise Lordship in so far my understanding Lordship, the warrant cases, not the summon cases Lordship, in warrant cases the complainant can be substituted Lordship in
Where is
warrant.
that law? This court.
Lordship.
Where is that law? What so far as this court knows that it is a proceeding before executive court. 145, their substitution is allowed in criminal law. But
Lordship.
then that apart, we do not know. You have to.
Lordship, because this information is also Lordship. I since I was also not aware of that my client has expired Lordship. I am coming to know from the opposite counsels, the petitioners, that she expired Lordship. I'll take instruction And Lordship, I'll come up otherwise on the next day that whether substitution is allowed. If substitution is allowed, then
That
Lordship.
is for them. You are not the master of the litigation. Whether substitution allowed or not allowed, that will,
Lordship.
isn't it?
Lordship.
Perhaps what you say is not correct. Anyway, we do not know that. We cannot say it with. What we'll do is we'll record your submission.
My lord, on being instructed, my lord, I'm submitting this.
Definitely,
My lord.
definitely. And we'll also record that you have appeared without filing any power.
Yes, my lord.
Now there is no other option, but then this is something very bad. There is now see, if this court now has to conduct an inquiry in this kind of matters, then it will be difficult, and it will cause more problem for the bar.
Lordship.
The conduct of each and every one will be doubted.
Lordship.
Very wrong. Something very wrong.
Lordship, I already got the signatures on the Wakalatnama, Lordship, but it might be due to some mistakes, Lordship.
That
the
is, it
Wakalatnama
appears to be a
was-
very serious mistake.
Lordship. I apologize for that, Lordship.
You just say, Mr. Yes. Yes, Miss. And you are appearing for?
Statement.
For state matter.
So you have no say in this matter, in this controversy.
Well, I have just now got to know I'll be able to assist matter
Yes,
in the next day.
Okay, it is. But then, Mr. Day, then what you will do so far as this thing is concerned? Then it casts a duty upon you also.
No.
Which way you deal with the.
Now the problem is this, my lord. The person who has lost the FIR, she expired. In the trial, what will be the outcome of that? I am not contemplating now, my lord. But my lord, now, until unless we know who is interested to be substituted or not, how can we substitute, my lord?
And there is no question.
There is
Even
no question for us.
even if the complainant is not substituted,
Yes.
the case against state will remain.
State will remain. Yes, my lord. I have to argue against the state now. A state will be a main party.
If that is the thing, we do not know.
Yes.
And what is the nature of offence involved in this case?
Fraud, my lord. Fraud. Misappropriation of money from the owner. That is the allegation, my lord. Whereas the owner has already given an NOC saying that no, I have no balance.
And
So
the
they was-
matter is yet to be charge sheeted.
Matter is yet to be charged, but I need to take instruction, my lord. I don't want to submit anything. Whether this is
My lord, investigation is could not be proceeded with because the accused is not cooperating. He's on anticipatory bail and he hasn't appeared even once. Even before the learned judicial magistrate, he didn't appear to verify his signature. So that's why investigation could not proceed so far.
Anyway, we'll see to all those things at the time when we hear this matter on merit. But then, first thing first, just say it is submitted by Mr. Yes, the learned counsel appearing for the petitioner. Mr. S. the learned counsel for the petitioner on instruction submits that the respondent number 2
yes,
has passed away recently. Stop. Miss MSP Bhattacharya appearing for the said respondent has no such information. Stop. It appears that no Wakalatnama also has been filed. It just do not say just say although Miss P. Bhattacharya is appearing on behalf of the has entered appearance on behalf of the respondent number 2, comma, it appears that no Wakalatnama has been filed by the learned counsel. No Wakalatnama signed by the respondent number 2 has been filed by the respondent number 2. Stop. Paragraph. Faced with the situation, Ms. P. Bhattacharya, learned counsel, prays for grant of some time to take necessary instruction in the matter. Read aloud. List after?
After? How many? 2 weeks.
After 2 weeks.
Hello.
25.
Yes.
May I please, Lordship? Your Lordship, this is a criminal petition, Your Lordship, to quash and set aside, Your Lordship, the FIR dated 16/6/2017, proceedings in GR case number 112 of 2019, and order dated 19/3/2025, passed by the Judicial Magistrate, First Class at Shillong, Lordship. Your Lordship, a brief of the case, Lordship, is that an FIR dated 16/6/2017 was filed against the petitioner, Your Lordship. Your Lordship, the FIR is at page 241, Your Lordship.
241.
Yes, Your Lordship.
Yes.
May I read the FIR, Your Lordship?
Yes, please.
On receipt of information from reliable source alleging serious defects in the execution of work by the accused contractor A4 against the contract excavation of trenches and laying of OFC through duct, etc. in 62 Gram Panchayats villages of Mauplang Block, East Khasi Hills, Meghalaya, awarded by Ratel Corporation of India by Letter of Acceptance, LOA number Ratel Tender OTER HQ 2014-15 and 724348 dated 11/04/2015, and amended LOA dated 26/07/2016 for contract value total amounting to rupees 3,82,14,940.88 joint physical inspection were carried out with effect 12/12/2016 to 15/12/2016 in 18 Gram Panchayats villages by a team of officers of CBI Shillong branch to confirm the alleged defects in the presence of officers of Ratel Shillong, including the site engineer of Ratel and the contractor and other independent witnesses, and a memorandum was drawn mentioning the findings of the joint physical inspection. Copy of the said memorandum is enclosed herewith. The joint physical inspection disclosed that the accused contractor had shown excavation of 14.113 kilometers trenches in respect of 16 villages as chase cutting in rocky area, and claim at the full approved rate of chase cutting, and rupees 2,54,829.01 per kilometer, total amounting to rupees 35,96,401.82. Though the actual excavation soil at sites were found to be of soft soils, which is payable at rupees 68,101.10 per kilometer, taking the depth of excavation trenches at 0.90 meters to 1.19 meters, and hence an excess amount of rupees 28,34,726.47 had been claimed fraudulently and dishonestly by the accused contractor A4 on the basis of false entries in site registers MBS by the accused officer of Ratel A1, A2 and A3. As a result of their criminal conspiracy, the joint physical inspection also disclosed that the actual excavation depths of the trenches at inside was
You are
at
A what? You are A? You are A4?
A4, Your Lordship, the contractor.
Okay.
The joint physical inspection also disclosed that the actual excavation depth of the trenches at site was at an average of 0.785 meters with minimum depth of 0.17 meters and maximum depth of 1.60 meters, which is payable at rupees 68,141.10 per kilometers, and hence total amount payable against 6.294 kilometers comes to rupees 4,28,880.09. However, the accused contractor in criminal conspiracy with the accused officer of Ratel had claimed at the approved full rate of rupees 1,38,282.20 per kilometers against 6.294 kilometers, showing depth of 1.65 meters, total amounting to rupees 8,57,000 38,760.17, and hence an excess amount of rupees 4,28,880.08 had been claimed fraudulently and dishonestly by the accused contractor A4 on the basis of the false entry inside register MBS by the accused officer of Ratel. During the joint physical inspection, it was also noticed that the accused officer of Ratel had maintained the site registers in a perfunctory manner without mentioning the chainage of the different depths of the trenches excavated site, indicating that the accused officers of Ratel had not physically made the measurement at site but mentioned different depths, including chase cutting at their own whim and fancy in a criminal conspiracy with the accused contractor. It is also alleged that no such chase cutting was done in other villages of Moplang block against the contract work in question by the accused contractor in criminal conspiracy with the accused officer of Ratel. Against the aforesaid excess amount claimed by the contractor, total amounting of rupees 30,63,606.55, Ratel Corporation of India had so far paid 50% of the claim amount, and hence the excess amount paid so far to the accused contractor comes to rupees 15,31,803.28, which is a loss caused to Ratel Corporation of India. Hence, the joint physical inspection carried out in the said 18 villages of Moplang block prima facie established that the accused officer of Ratel Shillong, namely Chanbor Kharkongor A1, Joint General Manager Shri Subarta Bhomik A2, Senior Manager, and Shri Kitborlang Korba A3, Project Engineer in charge Moplang block, in criminal conspiracy with each other and also with the accused contractor Shri Renol Noset and unknown others, abused their official powers, position, and fraudulently and dishonestly had falsely shown excavation of the trenches at higher depth in the site register MBS as against the actual depth excavation at site, and also falsely shown chase cutting in rocky area for substantial length, though the actual soil at site are soft soil, and thereby cause wrongful loss to Ratel Corporation of India to the tune of rupees 15,31,000 in rent 3.28 and corresponding wrongful gain to themselves to that extent. Thus, the aforesaid facts prima facie discloses commission of offences punishable under Section 120B, 420 IPC and Section 13(2), read with 13, Clause 1, Subclause D of PC Act 1988 on the part of the accused Shri Chanbor Kharkongor A1, Joint General Manager, Ratel Corporation of India, Shillong, Meghalaya, Shri Subarta Bhomik A2, Senior Manager, Ratel Corporation of India, Shri Kitborlang Korba A3, Project Engineer in charge Moplang Block, Meghalaya, Ratel Corporation of India, contractual, Shillong, Meghalaya, the contractor Shri Renol Noset A4 and unknown others. Hence, a regular case is registered against accused person Shri Chanbor Kharkongor A1.
Yes, you do not have to read it again.
Yes.
So,
Your Lordship, the matter was charge sheeted, Your Lordship, under section 120, 420 and 511 IPC, Your Lordship.
120, 120B or 120?
120B, Your Lordship. Page 246, Your Lordship, is the charge sheet, Your Lordship.
120B, 420
and 511 IPC.
511 attempt. Okay. Where is the charge sheet?
Page 246, Your Lordship.
246. Yes.
Your Lordship, thereafter, Your Lordship, we had filed an application, Your Lordship, praying for discharge, Your Lordship, under section 239 CRPC, Your Lordship. However, Your Lordship, our application was rejected by the Judicial Magistrate First Class at Shillong, Your Lordship. Your Lordship, the impugned order, Your Lordship, is at page 341, Your Lordship.
341.
Yes, Your Lordship. Your Lordship, may I read the operative part, Your Lordship?
Yes.
The operative part is at page 350, Your Lordship. Page 350, Your Lordship. Paragraph 43.
Yes.
Section 239 CRPC provides that if, upon considering the police report and documents sent under Section 173 and making such examination, if any of the accused, as the magistrate thinks necessary, and after giving the prosecution and the accused opportunity of being heard, the magistrate consider the charge against the accused to be groundless, he shall discharge the accused and record reasons for his doing so. Here, for the reason discussed above, the charge against both the accused person are not groundless, and if the assertions of the prosecution is to be taken at face value, there is a strong suspicion against the accused person. Therefore, the application for this charge filed by the accused number 1 and accused number 2 does not succeed. There is sufficient basis to proceed to frame charge under Section 420 IPC and 120B IPC as against Rela Nongse, and to frame charge under Section 120B IPC and in alternative Section 107 IPC as against Kit Borlang Purba. Your Lordship, we can see that the allegation made against the petitioner, Your Lordship, is under Section 120 IPC and 120B IPC, Your Lordship. Your Lordship, if we come to Section 420, Your Lordship, that is cheating and dishonest inducing delivery of property, Your Lordship. Your Lordship, by the meaning of cheating, Your Lordship, as provided in Section 415, Your Lordship, of the IPC, Your Lordship, may I read, Your Lordship, 415 cheating? Whoever by deceiving any person fraudulently or dishonestly induces the person so deceived to deliver any property to any person or to consent that any person shall retain any property, or intentionally induces the person so deceived to do or omit to do anything which he would not do or omit if he were not deceived, and which act or omission causes or is likely to cause damages to harm to that person in body, mind, reputation, or property, is said to cheat. Your Lordship, if we come to the first ingredient, Lordship, that is cheating, deceiving any person, Your Lordship. Your Lordship, the allegation made against the petitioner was that he carried out the work not as per item 2A, Your Lordship. Your Lordship, if we come to page 213, Your Lordship.
Page 230, 30.
213, 13, 213, Your Lordship.
Yes.
Your Lordship, if we see the second column, Your Lordship, that is item 2A, Lordship. Chase cutting, jackhammering, etc. up to the depth of 0.6 meters in rocky area, laying of DW pipes and trenches, protecting work, and filing the excavation along with the supply of protection material as per technical specification. Your Lordship, the work was not carried out as item 2A, Lordship. Proper reasons were given, Your Lordship. Your Lordship, in the third column, Your Lordship, the reason was due to increase in incremental quantity of foreground diversion and relocating of GP premises, Lordship. Your Lordship, this statement of first variation was given prior to the FIR, Lordship, and prior to the joint physical inspection, Your Lordship. Joint physical inspection was dated 12/12/16 to 15/12.
But then this is a document prepared by you, isn't it?
Yes, Your Lordship.
Then, if it is your document, what value it will have at this stage? You are an accused here.
Yes.
So that is what.
But Your Lordship, we have submitted this to Rachel, Your Lordship.
No, that is all right, but then this is by you. So if it is by you, it will not serve any purpose. This is your contention, your version. This will be proved that will be proved in evidence.
But Your Lordship, if we can see that from the letter of acceptance, Your Lordship, from the letter of acceptance, Your Lordship, right from the first amendment to the final amendment, Your Lordship, is still continuing, Your Lordship. There was no objection or complaint, Your Lordship, on the part of the retail, Your Lordship.
Because you were in hand in glove with the other co-accused. That is what the allegation is. That is why there was no opportunity of filing.
But Your Lordship, if
See, the problem is that, madam, you see, like, we have a limit in under 482 or 528, whatever you say. Our limit is very confined. We cannot go into all those documents and appreciate it, and you see, cannot give a finding whether that will result in conviction or not. Our work is only to see only whether the complaint or the charge sheet, as the case may be, discloses commission of any cognizable offence or not. So that is what. Now, if you say that the acceptance of entire allegation would not make you liable, then only we can. Otherwise, it's difficult. As has been by the trial court, it says that it's there is an indication of strong prima facie case. You have seen those principles in Vajanlal's case, isn't it? So you have to fit those things in any of the categories, and then only it will be very difficult for us to go for in-depth inquiry.
But Your Lordship, if you come to the power and the jurisdiction of the CBI, Your Lordship,
say it again, please.
The power and the jurisdiction of CBI, Your Lordship, the CBI has no locus, Your Lordship, to look.
Why?
Your Lordship, I would like to discuss and dwell with one judgment, Your Lordship, passed by this Honorable High Court.
No, first
Your
you tell us the law, then we will come to the judgment. Why CBI has no authority, you want to say?
Your Lordship, they had removed the PC Act, Your Lordship, in the charge sheet, Your Lordship. The PC Act was withdrawn, Your Lordship, in the charge sheet, Your Lordship.
So will it make the investigation defective?
But Your Lordship, the CBI doesn't have jurisdiction, Your Lordship, after filing the charge sheet.
No, what happens is, supposing in a case, after trial or during the course of the trial, the charge under PC Act is dropped. Will it make this entire investigation or the charge sheet defective, or it will render invalid in law?
But it falls under the state to look after, Your Lordship, but not the CBI, Your Lordship.
No, that is what I'm saying. Say supposing in such kind of case, does it make this entire charge sheet invalid in law?
Your Lordship, may I read the...
And what happens, say supposing trial court adds again. Trial court has the power to do it, isn't it? Under 216. So what happens if these sections are reintroduced again? I think you prepare better then. Just take some time. Come with something very solid.
Your Lordship, may I read the judgment, Your Lordship?
You can read the judgment, but then just you have to, the thing is that you have to point out something. But today it's already 4:15 also, I don't think, because
So what time?
there are,
Which judgment are
you see, we may not go make any, like searching and roving inquiry into the matter. Something which is very apparent, the factual aspect which is not disputed, on that basis. It should be something like that you assert and the other side say, no, that is not the factual thing, then it may not be a fit case for 482. We'll give her some time to just let her prepare. So, well. When? After 2 weeks? Always. Okay. I have done a counsel for the parties on prayer made by MS ADCM Learned Counsel for the petitioner. 2 weeks time is granted to enable her prepare further in this matter. Nothing more. You have said full time today. That is also a kind of achievement. Obliged.